Today I'm going to talk to you about 3 mistakes families with minor children make in their wills and estate plans. My name is Claire Langton Yanowitz, and I'm an attorney at the Yanowitz Law Firm, where we help families protect what matters most. We have been drafting wills, trusts, and helping families with probate for the last nearly 30 years. Okay, let's get started. Mistake number 1. People list their minor child as a beneficiary directly. Minor children cannot inherit directly. If they do, at death, this will trigger what's called a court-supervised conservatorship, where the child won't be in charge of the money. Someone else will be in charge of the money until the child reaches 18. If the funds get tied up in the conservatorship, the person in charge of the money will likely have to file an annual accounting with the court, and there can be numerous court hearings. It can be extremely cumbersome and just a huge waste of money when people pass away. So don't list your child directly, your minor child directly, as a beneficiary on your accounts. Instead, your child needs to inherit in a trust, or they need to inherit in a Uniform Transfer to Minors Act. Both of these options will prevent having a conservatorship triggered. A second mistake I see people make is they have 2 children right now, and then they have more children in the future. They have 3, they have 4 children, and they forget to update their estate plan. They forget to update the beneficiaries on their accounts. So when future children are born or adopted, it's important to relook at your estate planning documents and determine whether they need to be updated and or beneficiaries need to be changed. And then a third mistake I see people make is in naming guardians for their children. This is naming a guardian for your child in the event you pass away is sometimes the most important reason why families of minor children have an estate plan. They want to pick who is going to take care of their kids in the event they're not around to do so. And when we talk about picking guardians, we think it's important most of the time to list an individual person as opposed to a couple. When people list, my sister and my brother-in-law as the guardian, that creates an issue in the event at the time of my death, my sister and brother-in-law are no longer married. Perhaps they're separated. So then it creates this confusion of, did you want the kids to go to your sister, or did you want your kids to go to your brother-in-law? So it's best to name one person's name, if possible. If you would prefer that the guardian is your blood relative, and then if at the time of my death, let's say my sister is the guardian, she's still married to my brother-in-law, at that point he could, that you can take steps to have him become the second legal guardian of the kids as well. So thank you so much for your attention today. If you have any questions, give us a call. Our number is 507-252-8997. Also, make sure to subscribe to our YouTube channel so that you can learn more about estate planning, wills, and trusts as we add more videos to our channel. Thank you.